Good day, everyone. I am Rechell Cinas, and today I will discuss the topic about the legal aspects in tourism and hospitality, Chapter 7. For the objectives, we have to clarify transportation laws in the Philippines, define common carriers, private carriers, and charter parties, then explain obligations and liabilities of common carriers, then to summarize regulations for air, land, and sea transport, then highlight laws on safety, vehicle, and importation and traffic. For the contents, we have definitions and distinction between common carriers, private carriers, and charter parties, nature of contract carriage, obligations of common carriers towards passengers and goods, Articles 1733, 1755, then liabilities of common carriers for the acts of employee and strangers, recoverable damages, Article 2231, 2221, 2222, regulations governing air transportation, shipping, and land transportation, then specific laws regarding seatbelt use, transportation of importation of vehicles, and traffic laws. Then comprehensive overview of the legal framework governing transportation in the Philippines. So, the common carrier. It is a person or company that transports goods or people for any person or company and that is responsible for any possible loss of the goods during transport. A common carrier offers its services to the general public under license or authority provided by a regulatory body. The regulatory body has usually been granted ministerial authority by the legislation that created it. The, the regulatory body may create, interpret, and enforce its regulations upon the common carrier, subject to judicial review with independence and finality as long as it acts within the bounds of the enabling legislation. So, imagine na, you're shipping something important like a package or maybe gusto ka mo sakay og bus. These services is a common carriers. Their main job is to transport stuff or people from one place to another safely. Now, to make sure they are doing this properly, kay basin asa ra na mo abot imong parcel or giliko na ba hinon kas imong gisakyan, there are these regulatory bodies. Think of them as watchdogs of the transportation world. They have the authority to make rules and ensure that these carriers follow them. For example, kanang speed limit. So these regulatory bodies have can interpret and enforce these rules again independently as long as they stick sila on what the law say. In a nutshell, to sum it up, common carriers move staff and people while regulatory bodies keep an eye on them to make sure they're doing it safely and by the rules. So, next we have the private carrier is a company that transports only its own goods. The carrier's primary business is not transportation. Private carriers may refuse to sell their services at their own discretion, whereas common carriers must treat all customers equally. Again, it does not focus on transportation services. Pwede nilang i-decline din i-offer ilang services to other. Like for example, a company owns mini truck to transport whatever their product is exclusively or privately or private carrier. Then we have the party is the contract between the owner of a vessel and charter for the use of a vessel. The charter takes over the vessel for either a certain amount of time, a time charter, or for a certain point-to-point voyage, la voyage charter, giving rise to these two main types of charter agreement. Again, an example would be a company chartering a ship to transport goods from one port to another for a set fee or a fixed amount of money that is agreed upon in advance for a particular service or transaction. Voyage charter or time charter is the hiring of a vessel and crew for a voyage between a load port and the discharge port. The charter pays the vessel owner on a per ton or lump sum basis. The owner pays the port costs, fuel costs, and crew costs. The payment for the use of the vessel is known as freight. So remember, when we talk about common carriers, being those who transport goods or people, for a people, these charters fit right into that picture. So, take voyage charters for an instance, a shipping company nag-rent og ship to a business that needs to move goods from one place to another. That's a voyage charter in action. And then there's time charters. Think of a cruise line leasing a ship for a few months to handle the extra demand during holiday seasons. So during that time, mas dako imong control over where the ship goes and what it does. You pay the owner a regular fee for the time you use the vessel, and you're usually responsible for things like fuel and crew costs. That's a time charter in play. So bareboat or demise charter is an arrangement for the chartering or hiring of a ship or boat whereby no crew or provisions are included as a part of the agreement. Who rent the vessel from the owner are responsible for taking care of such things. On the other hand, we have the bareboat or demise charter. This is when you rent a ship again without any crew or provisions included. It is like leasing a car, you get the vessel, but you're on your own for everything else, from hiring a crew to stocking up on the supplies. So we have the Article 1732. Common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods or both by land, water, or air for compensations, offering their services to the public. So these charters are important as it offers flexibility. So business can hire vessels, and for companies like cruise line, it is a way to expand their services during busy times. So dili jud ta makaingon nga need jud mo palit og ships permanently. So it is a win-win situation. The nature of contract carriage. Article 1733. Common carriers, from the nature of their business and for reasons of public policy, are bound to observe extraordinary diligence and the vigilance over the goods and for the safety of the passengers transported by them. According to all the circumstances of each case, such extraordinary diligence and the vigilance over the goods is further expressed in Articles 1734, 1735, and 1745, number 5, 6, and 7, while the extraordinary diligence for the safety of the passengers is further set forth in Articles 1755 and 1756. Article 1755. A common carrier is bound to carry the passengers safely as far as human care and foresight can provide, using the utmost diligence of every cautious person with a due regard for all the circumstances. So, common carriers, like those transporting goods or passengers, are held to a high standard. They're expected to go above and beyond to ensure the safety of what they're transporting. It is not just a regular duty, it is what we call extraordinary diligence. For an instance, let's say you're shipping a fragile item and with a courier service, they're expected to handle it with extreme care, making sure it arrives intact. That's a part of their obligation as a common carrier. And when it comes to passengers, the bar is set equally high. Whether you're taking a bus, a train, or a plane, the carrier has a duty to get you to your destination safely. They're supposed to take every precaution possible considering all the circumstances. Think of it like nagsakay kag airplane. Their responsibility is not just to take you from point E to B, but they're held accountable for safety throughout the entire journey. These laws and regulations, like those outlined in Article 1755, are in place to ensure that common carriers uphold their duty of care. It is about providing peace of mind to the public and maintaining trust in the transportation industry. Article 1756. In case of death of or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observed extraordinary diligence as prescribed in Article 1733 and 1755. Article 1757. The responsibility of a common carrier for the safety of passengers as required in Articles 1733 and 1755 cannot be dispensed with or lessened by stipulation by the posting of notices by statements on tickets or otherwise. So, Article 1756 basically says that if something goes wrong during transportation and a passenger is hurt or worse, the courier is automatically seen as responsible unless uh, makaprove sila nga hibuhat na nilang tanan to prevent it. And there's Article 1757 which make it clear that dili lang ditso mapapha ilang responsibility by putting up a signs or making passengers sign a waivers. They cannot just say, oh, ikaw na ni-agree ka ani ni-agree ka ani pagpalit nimo sa ticket. No, they're still on the hook for making the passengers are safe no matter what. So for an instance, nabangga inyong bus nga giksakyan, a company cannot just point a sign states that travel at your own risk. Nya, gidaganan ang responsibility. So these articles are all about holding a common carriers accountable and making sure they prioritize passengers' safety above all else. Liabilities of common carriers for the acts of employees and strangers, Article 1759. Common carriers are liable for the death of or injuries to passengers through the negligence or willful acts of the former employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. This liability of the common carriers does not cease upon proof that they exercise all the diligence of a good father of a family in the selection and supervision of their employees. Article 2180, the obligation imposed by Article 2180 is demandable not only for one's own actions or omissions but also for those of person for whom one is responsible. So Article 1759 states that common carriers are responsible for any harm caused to passengers due to negligence or intentional acts of their employees, even if those employees were acting beyond their authority or against the carrier's orders. This means kung ang imong bus driver or imong employee causes an accident due to reckless driving, the bus company is liable for any injuries to passengers, regardless whether the driver was following the company rules. Moreover, this liability doesn't go away just because the carrier claims they hired and supervised their employees carefully. So, even if the company argues nga gisilik jud nila ug sakto ilang staff, ilagay po ng responsibility. Article 2180 expands on this concept, stating that the obligation to answer for one's action extends not only to the one individual themselves but also to those they are responsible for. So, if a bus driver causes an accident while transporting passengers, both the driver and the bus company can be held accountable under this article. Section 335 LTO Republic Act number 4136, restriction as to speed. A. Any person driving a motor vehicle on a highway shall drive the same at a careful and prudent speed, not greater nor less than is reasonable and proper, having due regard for the traffic, the width of the highway, and of any other condition than that there existing, and no person shall drive any motor vehicle upon a highway at such a speed as to endanger the life. Section 35 of the Land Transportation and Traffic Code says you need to drive at a safe speed, considering traffic, weight, and conditions. Going too fast or too slow can endanger lives. It's about driving responsibly and keeping everyone safe on the road. Damages recoverable from common carriers, Article 2231 in quasi delicts exemplary damage may be granted if the defendant acted with gross negligence. Article 221 nominal damages are adjudicated in order that a right of the plaintiff which has been violated or invaded by the defendant may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for any loss suffered by him. Article 222, the court may award nominal damages in every obligation arises from any source enumerated in Article 1157, or in every case where any property right has been invaded. In cases of gross negligence, common carriers may face exemplary damage, Article 2231. Nominal damage, Articles 221 and 222, are awarded to recognize violated rights, even if no substantial loss occurred. They ensure accountability and provide resources for passengers affected by a carrier's actions. Regulation of Air Transportation Legislative Act number 3909, the enforcement of rules and regulations governing commercial aviation as well as private flying. We have also the Registration of Aircraft Republic Act number 776, an act to reorganize the Civil Aeronautics Board and the Civil Aeronautics Administration to provide for the regulation of civil aeronautics in the Philippines, and authorizing the appropriation of funds therefore. Regulation of the shipping industry, Presidential Decree number 474. It is to integrate the development, promotion, and regulation of the maritime industry in the country. We have also authority to operate, Republic Act number 9295. It promotes the development of Philippine domestic shipping industry. Domestic ship operators are authorized to establish their own shipping rates, provided that effective competition is fostered and public interest is served. Regulation of the Land Transportation Clean Air Act of 1999 is a comprehensive air quality management policy and program which aims to achieve and maintain healthy air for all Filipinos. Seatbelt Law Section 4 of Republic Act 8750, mandatory use of seatbelts for their own safety. The driver and front seat passengers of a public or private motor vehicle are required to wear or use their seatbelt devices while inside a vehicle of running engine on any road or thoroughfare. Any passengers who refuses to wear seatbelts shall not be allowed to continue his or her trip. Law on Transportation of Animals, Republic Act 8485. It is the study of the operator to ensure the safety of passengers with animals being transported, to provide in all cases adequate, clean, and sanitary facilities for the safe conveyance of everyone. Law on Importation of Vehicles, Republic Act 7227. Some territories are declared as free port zone. Vehicles that is owned by a returning resident or immigrant and covered by an authority to import under the No Dollar Importation Program. Republic Act number 6537, also known as Anti-Carnapping Act of 1972, it shall the duty of the collector of the customs having a jurisdiction of the principal port should inspect the registration and the ownership of the vehicles. The Traffic Laws, Republic Act number 4135, it is the compilation of the relative law to land transportation and traffic laws which is being imposed to the traffic rules in our country. Then we have the Limited Access Highway, Republic Act number 2000, to limit the access of the facility and to regulate, restrict, or prohibit access as to best serve the traffic for which the facility is intended. So, in conclusion, the transportation industry operates under strict regulations and legal frameworks to ensure the safety of passengers and goods. Common carriers, private carriers, and charter carriers each have their own responsibility and liabilities governed by laws such as Article 1732 and Article 1755. Additionally, regulations cover various aspects such as air transportation, shipping, land transportation, and even laws regarding the transportation of animals and vehicles. These regulations aim to maintain safety standards, promote fair competition, and protect the rights of passengers and stakeholders involved in the transportation processes. So I think that would be all for today's discussion. Thank you for listening and goodbye.